ai tō tātou kīngi, tu heitia tangata, tu heitia tupua, tu heitia taniwha, rire hau, pai mārire. Kia koutou ngā mana whenua, ka nui, ka mihi. E mohio i tērā wāhi i raro i te kōti matua o Tāmaki Makaurau, te wāhi reu roa o ngaitai ki Tāmaki, nō reira e mihi kawana ki tērā iwi, ki tērā rangatira James Brown kua ngaro ki te pō. Nō reira koutou ngā mana whenua tēnā tātou. Ai te hunga ora kua taimai. Te whetu o te pō, the Honourable Justice Salmon tēnā koe. Te whetu tuarua o te pō, kei a koe paura, te kanohi ora o Marutuahu, o Panuku, o Maunga Authority, te mea, nō reira i te rangatira o te ture, te karau o te hungaroia Māori o Aotearoa i tēnei wā, nō reira tēnā koe. Ngā kaiwhakawā tēnā hoki koutou, ai te hunga ora tēnā tātou katoa. Taku mihi whakamutunga, te mihi ki o tātou wahine tō Aotearoa, te kapo o pango, 7's team, nō reira he mihi kawana kia koutou. Nō reira, ka huri ki te reo Pākehā e whakamārama e taku mihi i te pōnei. I started with karakia because, as you know, the Māori world starts in the spiritual realm and paving the way for us to be here together tonight. I acknowledge the Lord for giving us this kaupapa, this gathering today. I acknowledge those that have passed into that spiritual world, and I acknowledged our King Tuheitia. I acknowledge the mana whenua. You'll see strategically I didn't mention who those were. I'll leave those to Paul in a short time. I also acknowledged our special guest, the Honourable Justice Salmon, and of course Paul Majurey and our judges and all of you here today. And I specifically mentioned the Women's 7th team in the hope that Paul's speech will be just as grand. Nō reira, tēnā tātou kato. Kia ora.
Tēnā koutou katoa. Good evening, everyone. My name's Mike Duisberg. I'm a partner at Wynne Williams, and I'm the chair of the Auckland branch of the Resource Management Law Association. It's my pleasure to welcome you all here tonight. First off, with some housekeeping, let's get it out of the way. If there's a fire or another emergency, please exit the building the way you came in, back out and through the doors, and we go across Princes Street and to the Pullman Hotel car park. That's our get-together area. If you get lost, just follow the sound of screaming. That will be me. You'll find your way there. In terms of bathrooms, just out through the doors, left and then left again. For the folks that are joining us on the live stream, good evening. I have a sheet here. In today's world, I hope you all have learned how to use a live stream or a Zoom or a Teams meeting. I think the key function you need to know about, if you need help, shake your mouse and you'll see a little ... at the bottom of the screen. Click on that and click on the info button and you'll be able to get into the live chat to get help from our friends at Gig TV. We will have the opportunity to ask questions at the end. So if you're on the live stream, you can access the question function the same way by clicking on the little ... at the bottom and clicking ask a question. There's a long page of instructions, but you'll just have to work the rest out. I would like to move on. I'd like to make a special welcome to tonight's speaker, Paul Majurey and his friends and family. I'd also like to acknowledge the presence of our distinguished guests, Justice Fata, Chief Environment Judge Kirkpatrick, Judge Warren, to Justice Williams, who I think is joining us on the live stream, and Ms. De Lambert, previous Salmon lecturers, along with Justice Fata. And I'd also like to acknowledge representatives from Russ McVeigh, our sponsors tonight. In terms of tonight's lecture, despite its growing importance as a primary production export, this lecture is not named for the fast-growing and delicious fish, nor is it named for the company that gave us the seminal Supreme Court judgment on the New Zealand Coastal Policy Statement and what give effect to means. This lecture is named for the Honourable Peter Salmon KC, who I have the pleasure of introducing and to who I extend a warm welcome. Peter was admitted as a barrister and solicitor in 1959 and was a partner in Nicholson Gribben from 1961 to 1974. He joined then the Independent Bar, becoming Queen's Counsel, as the title then was, in 1983. During his 35 years as a partner barrister in Queen's Counsel, Peter was widely regarded as a leader of what was often called the planning bar. Peter was appointed as a High Court judge in 1996 and served on that court, and from time to time as a member of the divisional member of the Court of Appeal until his retirement in 2004. I'm just looking to Peter to make sure he's not shaking his head as I go through the history. Following his retirement, he sat on the Pacific Island Courts of Appeal and also served as a chair of two important inquiries. The first, the Board of Inquiry into the draft National Policy Statement on Electricity Reticulation, for which Transpower, I'm sure, are grateful. And the second, the Royal Commission of Inquiry into Auckland's governance. As much as the theory and practice of resource management law has been advanced by this impressive career, Peter's contribution runs deeper. He was a founding member of the Resource Management Law Association and served as its inaugural president. His support to the association over the years has been enormous and was recognised in 2003 by the presentation by the RMLA of the Outstanding Person Award, and in 2017 with the presentation of the Principal Environment Judge Bollard Lifetime Commemorative Award. Please join me now in welcoming the impressive, the Honourable Peter Salmon Casey.
Thank you, Mike, for those kind words, and you got it all correct too. So you don't need to worry. When I was talking to Paul some time ago now, he told me that he spent a third of his time in his law practice, a third of his time doing things for the Auckland Council, and a third of his time in iwi-related activities. When I had a look at all the things that he's done over the years, I thought most people would find any one of those as a full-time job. But apparently Paul has managed to do them all with aplomb and very thoroughly. So it's my pleasure to introduce Paul tonight. As I said, he's has this tripartite approach to life, and I'll just make a few comments about under each of those heads. First of all, so far as his qualifications are concerned and his past activities, Paul has specialised in environmental and Maori-related litigation. He's been involved in that sort of work for over 26 years, according to the bit of paper I got in front of me. I didn't think he was old enough to have done it for 26 years. He has appeared in all the courts in New Zealand, the whole range from, I'm sure you did a bit of district court work at some stage, the planning, the Environment Court, of course, the High Court, the Court of Appeal, the Supreme Court, and even when we still used to have appeals to it, what do they call it? The Privy Council, of course. Thank you. I hope that's my only Biden moment. So anyway, let's deal with what he does for the council. He's chair of Ekipanuku Development Auckland, which is a pretty big job. The Tupuna Maunga Authority, which is doing a very big job in Cornwall Park or One Tree Hill at the moment. I walk around One Tree Hill about once a week and I see the result of the activities there. Particularly the Panuku development must be a very busy part of his portfolio, I would think. I've already mentioned the range of activities he's involved in as a lawyer, but just to add to that, where did I see that? Just excuse me a moment. Well, oh yes, I think we'll move on to his Maori-related activities. He's been a treaty negotiator with the Crown on claims encompassing an area generally between Matakana Island, near Tauranga, and Matakana the town, north of Auckland. That's a big part of the North Island. And he's chair of the Hauraki Collective of Iwi and Tamaki Makarau Collective, and he's been involved in parallel negotiations for those collectives since 2009. Are they still running, or have they been settled? So tonight, Paul is going to speak to us on a subject which has assumed quite a lot of importance in New Zealand over the last few years, tikanga. The title of his address is a bit of a conundrum. Tikanga in Law Project Aotearoa, Originalism or Potemkin Law. Now that's something that I have no doubt Paul will unravel for us, and I look forward to hearing what he's got to say. So would you please all welcome Paul.
Tēnā koe te whare tawhito. I ngā maunga whakahiwa tamaki makaurau tū tonu. I ngā mana whenua te rohe nei, te waiohua Ngāti Whātua me Marutuahu, tēnā koutou, tēnā tātou. Nō reira, tēnā tātou i āhua tonga te pō. Kia koe e te tuakana ai Aidan, i tūwhera tō tātou hui, tēnā koe. Ngā mihi hoki kia koe te rangatira i Peter. Nō reira. It's my great pleasure to be giving this year's Salmon address. Just before the fact checkers come out in advance of me from Peter's kind address, I think that CV might be from a few years ago, so I wish it was only 26 years that I've been practicing the law, but the numbers are factor larger than that. I won't give the dates. Very great to see a number of former colleagues, friends, some family here as well. I'm conscious before I begin that there are members of the judiciary here tonight, and there are some decisions to be delivered that I'm involved with that, funnily enough, will address tikanga. So any perceived attempts at post-hearing advocacy tonight would of course be entirely coincidental. Yes, the title I've been told is something of a conundrum, and hopefully I'll unravel that. Alternatively, it may have been a way to try and attract some attention and interest in what this is about. But let's begin. I first encountered the Honourable Peter Salmon KC in the Court of Appeal in 1988. There's a clue about some of the years. He was leading the team for a proposed resort development in the Karikari Peninsula. I was a young junior to Gerard Curry of Rainbow Warrior litigation fame for EDS. It was my first appearance before the future Lord Cook of Thornton, then President of the Court of Appeal. To complete the legal pantheon, Sean Elias QC represented the Taitokero District Māori Council. Gerard often crossed swords with the future Chief Justice in the Mining Act 1971 cases of that period, but on this occasion we shared the trenches. Those were the simpler times of the Town and Country Planning Act of 1977. We had lost at the Planning Tribunal and the High Court, but Gerard thought that there was something in the Section 3 TCPA, Matters of National Importance, primacy argument. My abiding memories from that hearing are first that I wasn't confident of the outcome, having witnessed the supreme advocacy of Peter Salmon. Hardly surprising given he was the leading planning silk in the country. And second, the jurisprudential mastery of President Cook. Long before the mandatory practice of juniors having speaking time, Gerard gave me several minutes' notice that I would address the Court of Appeal on one of our make-weight arguments. My response to Justice Cook's charitably couched question was some incoherent mumble, as I recall it. Things didn't change, much change between then and seen as lordship again in the Privy Council in Maguire in 2001. Thankfully, I had Justice Fudder with me to do the law stuff. At the risk of wayward nostalgia, there are mostly fond memories of my years at Auckland University, the law school, then located across the way from here on the top floors of the General Library building, with sweeping and majestic views of the Waitemata. Those are gone now. Also fond memories of the academics, the likes of Northey, Coote, Venel, Palmer, Hine, McMullen and Taggart. Even then, tikanga Māori and the treaty were not foreign to our jurisdiction. Section 3.1g, as I've mentioned, declared the relationship of Māori people and their culture and traditions with their ancestral land to be a matter of national importance. And the place of the treaty in our constitutional arrangements was emphasised in Huakina, a Water and Soil Conservation Act case. Of course, these recognitions were expanded in the Resource Management Act 1991, especially the Māori trilogy of sections 6E, 7A and 8. These are the strong directions, as is well known, that Lord Cook observed to be borne in mind at every stage of the planning process. Together with the values and principles of kaitiakitanga, mana whenua, and tikanga Māori, all defined terms, they have been part of our statutory environmental law for over 3 decades. Reflecting on Maguire, it should come as no surprise that Lord Cook would also help point the way on tikanga in the law, with the suggestion that the tort of nuisance might be modified to accommodate tikanga. So even that little gem was good to see back in Maguire. Also of those times, I was part of a New Zealand Law Society seminar roadshow in 2002 with Judge Carrie Wainwright and then Professor Matthew Palmer. The things in my introduction from that time still seem somewhat familiar, and there I said, the Treaty of Waitangi again takes centre stage with an increasing triennial electoral focus on whether the sunset for historical claims will be imposed by Parliament. That historical Crown treaty breaches should be settled and done so expeditiously is a matter not much argued today. This has not always been so. Perhaps less understood is that the treaty is no more pervasive in its quotidian effect than in the environmental field, for it is in this fertile ground that treaty expansion continues, albeit incrementally when compared to the 1970s and 1980s, treaty supernova of high constitutional change, which awaits its next major illumination. A bit florid as I reflect on it, but that's what I was saying. Who then would have imagined a decade later the New Zealand Supreme Court sowing the seeds for the general recognition of tikanga in the Takamori decision, and Justice Williams, as he then was, charting the emergent third modern law interweaving of New Zealand law and tikanga in his very famous and very influential Lex Aotearoa in a heroic attempt to map the Māori dimension in modern New Zealand law. And then a further decade on, the Supreme Court supersizing tikanga in Alice. As far as celestial phenomenon go, I can't let it go, take your pick of Big Bang, supernova or black hole for these momentous legal developments. This paper is not a treatise on tikanga or harmonisation of the commentaries. There are much abler voices for this task, a number here tonight. And we now have the most important work of Te Akamatua o Te Turi, the Law Commission in a Generation, He Potama, led by Justice Fata. Rather, as per the title, confusing title of the paper, it is part reflection, part provocation, and part irreverence, all likely candidates for my tombstone inscription. Nature abhors a vacuum, and so does the law. The imperatives of political will and public interest have a major influence on the state of law in all democracies. So too the rise of populism and authoritarianism, tensions around immigration policy, and the far-reaching impacts of social media and rapid evolution of AI. Our nation is in one of those periods where the centre of the political continuum has realigned and social cohesion bears some fragility. Parallels might be drawn to the turbulent times of the Vietnam War years or the fourth Labour government market reforms. We have already seen in this term of government the repeal of the RMA replacement law, the disestablishment of the Māori Health Authority, party coalition agreements supporting to a point, Parliament recasting the treaty principles in legislation, changes to Māori language use in government agencies, and ministerial letters of expectation requiring agencies to refrain from considering the treaty. In the legal world, we have senior advocates and academics questioning the place of tikanga in the law, and some commentators describing tikanga as inconsistent with the rule of law, or even as far as cultural indoctrination. So some context. In its seminal Mātauranga Māori Y262 report, the hand of Justice Sir Joe Williams, there, and that was called Aotearoa Tēnei, a report into claims concerning New Zealand law and policy affecting Māori culture and identity. There, the Waitangi Tribunal adopted the metaphors of the peoples of Kupe and Cook as the imagery for identifying key traits of New Zealand's founding cultures. The hekinga, or migration to Aotearoa, was the last major move in the Polynesian diaspora, spanning several millennia, and was the last major human migration to an uninhabited landmass. We are the last, the loneliest, and the loveliest. The first peoples brought with them Eastern Polynesian, Hawaii, worldviews, which quickly evolved through acclimatisation to these large uplifted islands, to paraphrase poorly Abel Tasman. The spiritually and culturally symbiotic relationship between Māori and the environment is founded on whakapapa links between the cosmos, God's nature, and humankind. Māori see the world as a holistic, unified whole, which consists of spiritual, physical, interrelated realities. Māori beliefs include mauri and spiritual order among realities and the respectful use of natural resources. Private interests are subservient and shaped by the iwi imperatives. The British brought their worldviews that nature is objective and fixed, humans have a central position, and Western societies are progressive in science and economics. Western European concepts of private property and political liberalism are rooted in beliefs linked to efficiency and individualism. This includes Judeo-Christian religious traditions and the Justinian Code. These first and second systems of law, as Justice Sir Joe Williams described them, crystallised with Te Tiriti o Waitangi of 1840. As we know, the Crown obtained the power to govern in exchange for a guarantee to iwi Māori of their rangatiratanga over their lands, forests and fisheries, and other matters of importance to them, fundamentally tikanga. The treaty also provided the Crown with the right of preemption in respect of Māori land, while also affording to Māori all the rights and privileges of British citizens. The new order between the peoples of Kupe and Cook had promising beginnings in the first decade or so. Māori still owned the great majority of land. They fed Auckland and Sydney, owned schooners and flour mills. These were powerful commercial statements showing Māori had the skills and energy to flourish in the industrial age. In the legal sphere, tikanga still generally governed internal Māori disputes. As history sadly records, all that changed with the wars of the 1860s and consequential land confiscations and predatory Crown purchase practices. Tikanga took a back seat to English law, famously illustrated by the observations of Chief Justice Prendergast in 1877 that the treaty was a simple nullity and there was no Indigenous law capable of recognition by a New Zealand court. While the courts would walk back this judicial polemic, the first law was largely lost from view as an independent source of rights. The nascent state of harmony and prosperity between the races had evaporated. Fast forwarding, respected political commentator Colin James has observed, as he said, technically the treaty is between the Crown and Māori tribes. The Crown is an arcane euphemism for the government, which in modern New Zealand is the instrument of the majority. That reality will be exposed when the monarchy is disestablished and there is no crown, just the state. Meantime, sensibly, we will muddle along, adjusting our constitutional paraphernalia to fit the facts, usually sensibly, long after the facts have changed. Now, some of the constitutional fog alluded to here can be accounted for in our historical narrative. As a modern nation, our collective histories were not born of independence from a colonial power through military revolution or political negotiation, not from balkanization nor military coup. We did not experience a singularity of national defining event among the founding cultures that characterises many other countries. Yes, the Treaty of Waitangi is our genesis, but it was not seared into our overall national consciousness to become a cornerstone of universal identity. Distance and time were largely at play in this equation. The Crown's representatives during the treaty process were few and largely unknown to the relatively sparse British population. Completion of the constitutional acts took place in London, and the massive settler influx of the mid-19th century had little awareness of or regard for a treaty with which they had no involvement, and which, frustratingly for them, restricted their acquisition of land. There's water in my water. We have tended constitutional incrementalism in keeping with a collective psyche grounded in deep-seated pragmatism and introspection overlaid for many years by a real or imagined dependence on Britain. Apart from some sporadic, though internationally renowned flourishes, and of course, true universal suffrage and social security and welfare are examples, we follow more than we lead. And we generally shy away from pursuing bold legislative and policy development unless something is truly broken, there is material political advantage, or a perceived last term of government prompts policy action before the Treasury benches are lost. Moreover, under MMP, there has been much deferred maintenance and development as the price for securing electoral fruits by not venturing outside the political centre, a la the perennial superannuation and capital gains debates. The main exception has been where heroic legislative promoters have pursued real change regardless of the electoral math. Notable examples include homosexual, prostitution, anti-smoking, and anti-smacking law reform. On the constitutional front, the most significant generation development was the introduction of MMP in 1993. But that was no quick thing and was the product of both major parties breaking major electoral promises. We have no written constitution and no real history of civics and citizenship education in our national curriculum. Little wonder then that our constitutional arrangements are opaque for much of the population, and the place of the treaty is yet under review. The historical narrative, somewhat dark, isn't it, also explains why there is still no real consensus as to our constitutional and rights framework, the Three Waters debate being a case in point. Seen through a Māori lens, the Crown's constitutional legitimacy is depending on keeping faith with its treaty guarantees. While the Crown has enjoyed the fruits of that exchange from the outset, and certainly since the military invasions and land confiscations of the 1860s, neither the treaty nor Article 2 promises have recognition in our fundamental constitutional arrangements, entrenched laws or Bill of Rights. Thus, our tendency for constitutional timidity has not confronted the parameters of the treaty, with a consequent legacy of being unfinished business which plays out in ad hoc fashion. Seen through a majority culture lens, New Zealand is founded on the Westminster model of the rule of law and sovereignty of Parliament, and the settlement of historical treaty breaches, mainly around financial compensation and land returns, is generous and squares the ledger, especially given the treaty has no inherent legal status. Moreover, there is more than ample recognition of Māori in legislation and policy support. Thus, we should look to the future and not the past. I've belaboured the setup just to give that context to now getting into tikanga. So tikanga. To the extent the development of tikanga in the law is a collaborative enterprise carefully planned to achieve a particular aim, it can be seen as an evolving project, just as the ongoing experiment of a democracy. This has been no quick thing, though the pace could be said to have quickened a little of late. Justice Fata has referred to the renaissance of Māori issues jurisprudence post the 1970s as a Cambrian explosion. And the Supreme Court gave a summary of the modern judicial recognition of tikanga in the Smith decision. And that summary is quite helpful, and this is what they say. In more recent times, the common law has re-engaged with tikanga. In Takamore and Trans-Tasman Resources and Ellis, this court considered the relationship between tikanga and the common law as it operates outside the sphere of customary title. To summarise the essential conclusions reached, tikanga was the first law of New Zealand, and it will continue to influence New Zealand's distinctive common law as appropriate, according to the case and to the extent appropriate in the case. There are, of course, questions, and these have been widely discussed in the commentaries. First, was Ellis the right case to spearhead momentous changes to our common law? Perhaps not. There's not been a dearth of suitable cases, but that waka has paddled. Second, has the vehicle of judge-made law for this fundamental legal development been universally accepted by the profession and academics, let alone Māori? Again, the answer can be said to be no. Are the parameters of this law clearly set? Again, no could be the answer. And do the institutions that will influence and implement this law, the universities, profession and courts, possess the requisite knowledge and skills? Again, there could be a no answer. But a bit of perspective. Short of a U-turn by the Supreme Court a la Rowan, Wade and Dobbs, or some legislative override a la the government's proposal to overturn the Court of Appeal in Edwards, the future trajectory of tikanga in the law will need to confront some of those questions. And the level of success will influence the level of acceptance. Perhaps more charitable answers to those questions would be not yet, given the courts will presumably elaborate on the rules over time, the inclusion of tikanga by the Council of Legal Education as a compulsory component of law courses, and the growing number of judges, Māori in the judiciary. I now discuss some of the topical themes with tikanga in law project. Mandate and legitimacy. A decision as momentous as the Supreme Court 3-2 majority in Ellis was naturally met with widespread commentary, including the usual tropes of judicial activism and politicians in robes. This would not have come as any surprise to the court given the weighty cautions in the considered dissent of Justices O'Regan and Arnold. And this is what they said. So the tikanga issue has come before the court in an uncontested environment and in circumstances where the court has not had to address a number of difficult issues of both legal and constitutional significance. These include how the court can identify when tikanga is relevant to the case at hand and when it is not. If it is relevant, how should it be addressed? Whether tikanga is a separate or third source of law, how the relevant tikanga should be brought to the court's attention, how the application of tikanga in one area of the law affects the common law in another area, and how to avoid tikanga being distorted when applied by courts. Also, how precedents are affected by arguments that tikanga should be taken into account when it has not been taken into account in an earlier decision. The adverse commentaries have not been lost on the Supreme Court majority, with some members adding to the discourse extrajudicially. For example, the following observations of the Honourable Dame Justice Susan Glazenbrook. She observed, first, there is an expectation that the way the courts will apply tikanga will become more sophisticated as tikanga concepts become more well known and as projects such as the Law Commission project on tikanga and the law are completed. There is no need to panic, a phrase used multiple times in that article. Tikanga being part of the common law does not mean it will somehow replace the common law wholesale, and tikanga, like the common law, will cede to statute. Third, Ellis does not require tikanga to be addressed in all cases, only where relevant, though it is likely the case law on tikanga will increase as counsel get more attuned to the idea of tikanga being part of the common law and are more prepared to bring up tikanga issues where these are relevant. And just because tikanga might be part of the common law, this does not mean it will necessarily be directly applied. In fact, tikanga is likely to be directly applied, at least in the near future, in a relatively limited number of cases. Where tikanga will likely be of particular assistance is where a question arises on how to develop the New Zealand brand of the common law such that it is attuned to New Zealand's society and values. There is a febrile contest of ideas on these matters, and it's at the heart of where we're at with tikanga in this country. So, turning to a few of the commentaries. In the 2023 Robin Cook lecture, Professor Jason Varas covered 3 types of judicial development of the common law. First, he conceived of ordinary legal development, there such changes are reconcilable with the established legal framework and are entirely orthodox. For example, a new exception to an existing rule, as this achieves continuity and reasonable stability. Second, changes to deeper commitments. Here change should be slow and tentative, and when done properly, almost imperceptible. To avoid instability, the court should not to effect paradigm shifts in single judgments. Where major changes are required to reflect shifts in societal values, Parliament is the proper forum. And the third type of change he covered are those that judges cannot make. For example, change in parliamentary sovereignty. Another would be a fundamental change to the legal status of the treaty, such as being directly actionable in state law. Now, that third change was echoed in an important article of Jack Hotter for the Supreme Court's 20th anniversary conference. And in that article, Jack said, perhaps most strikingly in explaining the presumption declared by the court that statutes are to be interpreted consistently with Te Tiriti as far as possible, Justice Glazenbrook said of Te Heoheo, the case that was referred to, in a footnote, while the Privy Council in Tukino, commonly cited as Te Heoheo Tukino, held that the courts cannot directly enforce Te Tiriti unless it's incorporated into statute, subsequent decisions had nevertheless dealt a heavy blow to Tukino's crumbling facade. Jack goes on, more fundamentally, moves by the courts to constitutionalise the treaty involve a profoundly political topic. In 1985, the White Paper on a Bill of Rights for New Zealand proposed that the treaty be recognised as and affirmed as part of the supreme law of New Zealand. That proposal failed on the basis of extensive political opposition. It has not been revived, and I continue to think that attempts to achieve a comparable outcome by judicial decisions involve significant issues for the political reputation and legitimacy of the courts. As to Ellis itself, Hodder raised searching questions on the majority decisions, and he observed, one way to develop the common law is to redefine it. Ellis marks a significant move away from the Takamori approach, which emphasised that tikanga incorporated values might, in some circumstances, inform the general law. The Ellis majority judgments differ somewhat on the extent to which they describe tikanga as part of the common law, as a separate system of law, as a factor in development or application of the common law. But the enlarging intent is clear. Beyond that, most things are far from clear. The article then frames various questions and challenges to the direction of the common law arising from the uncertainties of tikanga as a set of values and principles rather than legal rules. And Hodder concludes, the question remains whether the must-serve Māori component of the Chief Justice's proposition requires something different. It seems likely that this was intended to refer to the inclusion of tikanga source values in the common law. It might include the idea that certainty and consistency are contrary to the very nature of tikanga and thus inappropriate. If so, that leaves the fundamental question about whether the common law is understood as essentially a body of fairly predictable rules, legitimated by recognition and application over time, and equally applicable to all persons or not. If it is something else, what is it? So having given that side of the commentary, we turn to those in turn being critiqued. And they were covered in a recent paper of Justice Fata that noted the deeper constitutional issues about judicial mandate reveal that modern New Zealand law is only just coming to grips with the possibility of two legal systems coexisting. This is at its heart about legal pluralism and how we go about charting a course for engagement between tikanga and New Zealand law. Tikanga is not simply a collection of abstract ideas. It is a living system operating within a clearly defined frame based on whakapapa, including the requirement for proof of entitlement or basis for claim, and as a coherent system of norms. While the application of tikanga values may vary according to context and it's not always rule-bound, it is not an unfettered or indiscriminate system. Any claim that has no clear whakapapa basis and or is inherently inconsistent with the ordinary operation of tikanga as a coherent normative system is unlikely to survive close scrutiny. Here, Potama emphasises that the common law method applies its own guardrails to maintain the integrity of the law and law's fundamentals. The trajectory of tikanga in the law is incremental, with the leading authorities maintaining the coherency and stability of the common law. The recognition of tikanga where it is relevant, tikanga must not be contrary with statute or binding precedent, and in the event of genuine conflict, common law or statute will prevail. It is therefore difficult, His Honour observed, to see how values recognition in this way undermines law's integrity, certainty or stability with those guardrails in place. And as a call for perspective, just to remind us of where we sit in these constitutional arrangements, in terms of the concerns raised in those commentaries, Justice Fata noted, because tikanga recognition also remains entirely discretionary, Aotearoa New Zealand's claim to formal equality and a genuine common law is weak. The comparison to Canada in this regard is stark. Speaking of North America, the influential Canadian Supreme Court has not been shy in its exercise of judicial discretion. The following observations of former Justice Rosalie Abella, sometimes known as the Canadian RBG, Ruth Bader Ginsburg, are thought-provoking, especially to a New Zealand audience. And she covered a number of important observations. First, democracy is multifaceted and not just about majorities. The job of governments is to reflect the majority. The job of independent courts, not required to be popular or elected, is to be the guardians of rights and act as guardrails against the state. Do we want judges taking polls to find out what to do or to make the best assessment of rights based on law? The law isn't frozen in amber. When you interpret, you make law. The whole history of the common law is judges making law. The tropes of judicial activism, etc., employ rhetorical devices to presumptively dismiss progressive decisions. They are never used when a court behaves in a conservative fashion, and as she says, what's the opposite of judicial activism? Judicial inactivism. The Canadian Supreme Court in the early 1980s went marching into the field of constitutionally protected rights in full throttle. There was no, should we take baby steps? Or this is brand new, so we should be a bit careful. They just went at it. They protected affirmative action, created equality rights, etc. They weren't shy about being bold. She finally observed the Canadian court stopped considering SCOTUS judgments, Supreme Court of the United States, due to their legal insularity and regression to originalism. We got there. For the followers of US law and the strident direction of SCOTUS is taken with originalism of the Robert Bork and Antonin Scalia variety, we are set to see our own version of sorts play out with the proposed treaty principles legislation. Another respected political commentator, Audrey Young, had this to say last year. It's a curious thing that the further we get from the signing of the Treaty of Waitangi 183 years ago, the more convinced certain people have become about what was in the minds of those who signed it. Turning to state whakawhanaungatanga. As noted, the experience thus far of the coalition government has not been dull, and the tensions between the branches of government have been on full display. That is nothing new in our version of democracy. One high-profile example is the summons by the Waitangi Tribunal of a Crown Minister as part of an urgent inquiry on whether a proposed legislative repeal was treaty compliant, with the summons being challenged by the Executive on review. There have been contrasting commentaries on the respective merits of the stances taken by each of the state actors. Of note was a speech to the Law Association by the Attorney General, the Honourable Judith Collins KC, who concluded, "Summoning a minister on a matter of proposed legislation was a highly unusual move by the Waitangi Tribunal, and the Executive's action essentially nullified the effect of any such summons. In conclusion, since responsible government was established in New Zealand in 1853, our constitution has not remained static. In reality, it has been the opposite. But comity between branches of government has underpinned every iteration, and it is critical to our democracy. The reciprocal obligations of comity recognise that each branch of government approaches its tasks with conscientious integrity and respect for each other. By acting with a mutual restraint and respect, constitutional actors avoid escalating conflict. This is critical to ensuring the New Zealand people retain confidence in our constitutional arrangements and in the actors which exercise power on behalf under it." The message is quite clear, and for New Zealand, a bit like exercise diplomats using adjectives, this is heady stuff. I want to cover now the Māori response, which is very important in this equation. Support in the Māori world for the recognition of tikanga in the law has taken various forms. There is the ever-growing body of commentary from Māori in the profession and academia lauding the development. There is also the participation in cases like Alice of experts in mātauranga Māori and senior Māori advocates assisting the senior courts. And in true Māori fashion, there has been a rapid uptake of the litigation opportunities arising from the recognition of tikanga. It is, however, not all one-way traffic. There have been powerful critiques, for example, from Annette Sykes. She cautions the need for special care before Māori raise arguments in the courts, which may have unforeseen consequences beyond any particular factual matrix. This is because there are cases reinforcing the myth of tikanga in Pākehā law, and it's just window dressing. As she said, I would hate to think we are allowing the use of Māori values to advance a position of justice which will be denied Māori of the institutional pitfalls that Māori confront in their quest for justice daily. Then there is the world view that the recognition of tikanga in law matters less than its wider constitutional setting. Again, Annette, so what do we need to do for transformative change rather than co-option? We have to be talking about constitutional change. The vision for a decolonised Aotearoa in Mātiki Mai is not about a hybridised justice system where the question is whether Māori values will be recognised within a colonial paradigm. It is about having a tikanga system of justice based on our values that work for our people. Moana Jackson is clear that will only happen when Māori are prepared to stand up for our justice and not co-opted by participation in the colonial apparatus. We all know that in our hearts, but if we say it out loud, that means we have to be prepared to say what change really means and take the risk of being ostracised, physically attacked, and lonely. That sounds radical to some of you, unachievable. It is more comfortable to seek incremental change and acceptance within the status quo. I have never been about what's comfortable because when we lower our ambitions, it is our people who suffer. Constitutional change means systemic change, not reform. Where is the next generation of lawyers who will help make that happen? Another important theme in this discourse is the concern with the potential for arrogation by the courts of responsibility for developing tikanga or its codification. Justice Whare emphasises the need to preserve the integrity of tikanga. The law's evolution must not derogate from or assimilate tikanga. And Justice Glazebrook makes a similar point of ensuring we engage in decolonisation, not recolonisation of the law. Justice Palmer put it this way in the Ngāti Whātua case. Just because a court can do something does not mean it should. One reason for judicial caution is that legal precedents in case law will not be authoritative as to the content of tikanga. This flows from the ongoing capacity for tikanga to change and for there to be difference in tikanga and the application of tikanga between iwi and hapu. Iwi and hapu create, determine and change tikanga through exercising their rangatiratanga. Courts do not and cannot make, freeze or codify tikanga. If a court approaches tikanga in a particular case, it must recognise tikanga on the basis of the evidence before it for the purpose of that case. What is recognised by a court cannot change the underlying fact or validity of tikanga on its own terms. A second reason for caution derives from the inherently difficult task of transcending culturally specific mindsets. In recognising tikanga, common law courts must hold in check closely an unconscious tendency to see tikanga in terms of the English law heritage or New Zealand common law. They must be open to seeing tikanga on its own terms as a distinct framework. A court's caution in approaching tikanga must be heightened when the content of tikanga is disputed within an iwi or hapu or between iwi and hapu. As the Aucklanders in the room might have noticed, Ngāti Whātua case involved such a dispute. Their Ngāti Whātua Rā case sought affirmation from the High Court as to its mana whenua to the exclusion of other iwi, which is why its application was heavily contested. Indicia of the scale of the contest include there were multiple iwi parties, it was an 11-week hearing, there was oral evidence from 37 witnesses and affidavits and briefs of evidence from another 38, over 3,000 pages of notes of evidence, and over 500 pages of legal submissions. The High Court decided Ngāti Whātua Rākei has mana whenua ahika status according to its tikanga, histories and traditions. The court also made a companion declaration that other tribes do not recognise exclusive mana whenua ahika status as their tikanga, histories and traditions differ. In these types of cases, there are strong worldviews that what is tika to one tribe may not be shared by others. Each tribe has different histories in tikanga, and none are inferior to the other. In the world of tikanga, does that mean the state and the law should ultimately be respectful but agnostic? Then there is the fundamental question of whether tikanga should even be ventilated in the courts. Almost all the pukenga in the Ngāti Whātua case agreed tikanga disputes between iwi should not be in the courts. The alternative view is that rights should be capable of judicial determination, and Justice Palmer reflected the tensions in this way. He said there are ways of resolving disputes about tikanga which are consistent with tikanga and ways which are not. Recourse to courts without agreement between the parties is not obviously tikanga consistent. As a matter of tikanga, of course, tikanga consistent dispute resolution processes must be preferred to non-tikanga consistent court resolution of disputes about tikanga. Indeed, resolution of a dispute about tikanga by tikanga consistent processes may be more enduring than a ruling by a court. If tikanga consistent resolution of a dispute about tikanga is not feasible, then recourse to a court may be appropriate as a matter of law. That necessarily follows from tikanga being part of New Zealand law. The quintessential function of courts is to determine disputes about law. That may include determining disputes about tikanga. As arose in discussion with Mr. Warren, in our front here, and Mr. Mahuika, in closing submissions, in some ways litigation is now the modern alternative to resolution by battle, which used to be but is no longer available to break a deadlock over tikanga. I do not rule out a court doing so where a dispute generally requires resolution as an ultimate alternative to battle. Whether such a decision is tika and consistent with tikanga is another matter. So in conclusion, where are we? The Supreme Court has not pushed the pause button. In the Smith decision, it leaves open the door to further substantive recognition of tikanga in the law. Rather than an example of floodgates, the Supreme Court will probably counter, as it did in the decision, that the application of tikanga to tort actions is nothing new, having applied since the early days of the colony. The general courts have run with Ellis, with seeming widespread judicial acceptance of the rationale for the new or old way, let alone that little matter of precedent. Litigants have not been slow in carrying the ball either, with tikanga steadily appearing across the legal spectrum in cases of treaty settlements, crime, torts, family law, and procedure. There are principal challenges to the direction of the law is taking, with ongoing concerns over stability, durability, and predictability, as well as appropriation. These issues will need to be taken seriously as part of the court's political capital so important to our constitutional balance. Finally then, while made in a different context, Lord Atkin's famous observation that finality is good, but justice is better may be apt. Expressed another way, with apologies to Irving Berlin, the pearl doesn't come without some irritation in the oyster. Well, thank you for your time, and I'll hand it over to the higher beings. Tēnā tātou.
Thank you, Paul, for that, for your lecture. What I've noted down, and I certainly couldn't note down everything, but I noted that it was certainly provocative, it was poetic, but it was also profound. And so thank you, and please join me in thanking Paul again. Now, we did promise the opportunity to ask questions, so if there are any from the room, we will have some microphones. We'll find some microphones, or you can speak loudly, and I'll just go and get a device so I can check if there are any questions from the. Thank you, Alan. And Paul, please come up.
Kia Paul, Alan Losterho.
Kia ora.
I've lived on the Czech Islands. Wondered where the Majurey
I think the best answer to that is that's not my area, despite the large territory that Peter talked about that I'm involved with. All I would say is that there is a lot of literature. There are Waitangi tribunal reports on this in terms of the history and context of wharekuri, or rekuhu as it's known. And I'm certainly aware that going back to my university days, there's been different stages of educational awareness in terms of some of those early ethnologist views about those islands. So I think that's the safest way to answer your question. Otherwise, there's a certain Maui Solomon who might give me a call afterwards.
I have a mic now. Anyone?
Very good.
Right, well, thank you again. Thank you, Paul. And I'd now like to just hand over to Chief Environment Judge Kirkpatrick.
Tēnā koutou katoa. My name's David Kirkpatrick. As has just been indicated, I'm the Chief Environment Court Judge. Prior to that, I was in practice as a lawyer, and in part of that practice, I was involved in cases on the other side from a lawyer named Peter Salmon, QC in those days. And on a few very memorable occasions, I was able to be a junior to Peter Salmon. I carry those memories with me. I'm going to talk about the Salmon lectures in the lecture series, and I'm going to start at the beginning, which I was always taught, including by Peter, is a good place to start. At the beginning, in 2002, Peter Salmon Casey, who was then the Honourable Justice Salmon, delivered the inaugural Salmon lecture. And he addressed sustainable development in New Zealand, and he identified justice and sustainable development as ethical concepts and societal norms which are connected. And the connection, he said in the lecture, should inform the legislative process in making laws about the effects of people's activities on the environment. And he acknowledged that this would not be an easy thing. It would require major structural reforms in areas of policy design, administration, business management, production and consumption, and education and public awareness, with cooperation needed on local, regional, and global scales. So not a big ask. Peter's lucid articulation of a fundamental basis on which to consider justice and the effects of human activity on the environment has, I say, served as a beacon in our field. He humbly expressed in his lecture hopes that his lecture would not be the last, and that after future lectures, people would say, well, that lecture was even better than last year's. And Peter, your hopes have become reality. The Salmon lecture is a highlight of the year for all who share an interest in resource management law and practice. The quality of both the speakers who followed him and the lectures they delivered has been of the highest order. And there's a list available online of the 22 lectures delivered before this evening. And then we have this evening's lecture. Thank you, Paul. Which shows the breadth and depth of the subjects addressed by senior judges, senior practitioners, senior academics, and public officials, and the late Rod Oram, a renowned public commentator. I'd like to take a few minutes, if I may, having reread the lectures in preparation for this evening, to address several motifs that I suggest emerge from the lectures. And the interesting thing to me was that these motifs are repeated and developed in enlightening ways by each of the speakers, and including the speaker this evening. And I offer my understanding of these. Firstly, the concept of justice is not limited to relationships among people, but the effects of people's activities on the environment that we share must be included. And importantly, this concept does not require the personification of things or the anthropomorphizing of other creatures. The intrinsic values of the environment and all the things in it, including places, ecosystems, and plants and animals, together and separately, are expressly within the ambit of environmental law and science, and thus within the scope, as Peter framed it, of environmental justice. And the concept may be understood both through Tikanga Māori, as I roughly conceive of it, recognising shared whakapapa and whanaungatanga, and similarly through ecology and economy being connected rather than separated. And these relationships should inform any assessment of what the appropriate permission for and controls on human activity may be. Second, the scope of environmental law is prospective. We should learn from history that the data, rather than just the anecdotes, and the science built on them are important in making predictions and guiding how we plan for the future. And this prospective focus is not on distributing liability, at least not to the same extent as in the general law, but on promoting good or better outcomes for both our activities and the environment, improving where we can, protecting what we can. Thirdly, the theories of what rules are and what a consent is recur throughout the speeches. The framework of a management statute leaves a good deal to be worked out at the level of subordinate legislation. Allocation of resources, something for which the RMA was not originally designed, has emerged as a driver of claimed rights. But the corresponding obligations which are related to such rights have not always been given the same attention. If the right to use one's property is held by everyone, then the exercise of that right must require reciprocal recognition of the same right by others, and the consequent challenges by and contests between claimants of rights without recognition of that reciprocity have strained the management framework and distorted both the objectives and policies which should guide the rules and the devolved administration of the system by planning, consent, and enforcement authorities. Next issue is that addressing the breadth of the environment is not without consequential issues. A broad approach to scope is essential. It is not rationally feasible to treat the anthropogenic adverse effects as something which is somehow outside the environment. But keeping the whole picture in focus as the frame gets bigger is hard. Deciding a case on its merits appears just, and the small exceptions may be trifling until they are all added up. Determining relevance using the sharp scalpel of the law of evidence, may not cut through the complexity of interrelated ecosystems and of compound causalities. Determining requisite priorities in a plural democracy requires finesse, which, as tonight's speaker has so well demonstrated, as with so many other resources, is often in short supply. The framework of resource management law includes not only rules and the whole concept of what law is, but also objectives and policies, sometimes called soft law, at least until a court of competent jurisdiction describes it as directive. The conditional wording of plan provisions, often drafted with an eye to the political preference, not to say anything negative, creates a dilemma when enforcing a regulatory provision in a legal system which is based on binary analyses. The process, and this is finally the motif I draw, the process of identifying options for the way forward can face multiple hurdles thrown up by implicit biases and other similar fallacies of cognition. Too often a person may identify a preferred outcome without considering reasonable alternatives. Too often a person may shy away from a hard choice, even where the evidence clearly indicates that delay will only make the future choice even harder. These lectures that Peter has initiated and that have continued now for 23 years, in my view, provide a tonic for those who may find these issues to be indigestible. And I should say this as well, in terms of all of you gathered here tonight to hear this presentation, that speeches are an important kind of public discourse, and the power and effect of spoken words on the minds of those who hear them can be profound. These presentations are important contributions to the discourse on a topic of existential concern, and that is how we live in the environment. The technologies of writing and publishing in various media, the wonders of transmission, mean that the reach of the speaker's ideas can extend even further. And so now, following tonight's lecture by Paul Majurey, we have 23 lectures of the highest quality that make us think about justice and the environment. And I look forward, Peter, to your hopes remaining a reality for many years to come. And so on that basis, I wish to present to you the latest collection of the lectures to go with the 2 volumes that have previously been put together, and I acknowledge the work of my predecessor in relation to this, Trevor Dale Winterbottom. And I'd like to present to you volume 3 of the lectures that bear your name. And I'm told there's no time for a right of reply, but if you'd like to take time.
Well, I'm not going to take it on, but thank you for this. I've been very keen to see the lectures made more widely available than they are at the present. I believe that they're a great source of research for students, for practitioners, and so the association is in the process, as I understand it, of making all the lectures generally available to the public, and that's something which I really commend.
And that's all, folks. Thanks again to everyone. Thank you, Judge. Thank you, Peter. Thank you, Paul. There is time set aside if folks would like to mingle. I think the bar will open again. You're welcome to stay and enjoy the hospitality, but please join me once again in thanking our speakers in the usual way.